This is Michael Popok, Legal AF. Even though Donald Trump's been indicted twice within 2 months, one in state court in New York, one in federal court down in Florida, his woes and legal problems of his own making continue. On May 9th, a jury of 9 people, 6 men and 3 women, found that he sexually abused E Jean Carroll, former writer and advice columnist for Elle magazine, in the dressing room of a department store, Bergdorf Goodman's, in the spring of 1996, and awarded her damages for those various things, awarding her, just to be clear so we can follow along, $2 million for sexual abuse, $2.7 million for defamation, because he denied ever knowing her and called it a hoax, which was untrue because the jury found that she was sexually abused in that dressing room, and then awarded her $280,000 of punitive damages, totaling over $5 million. According to Joe Tacopina, the lead trial lawyer for Donald Trump during the trial, who did all of the major witnesses, including the cross-examination of E Jean Carroll, in a trial in which Donald Trump put on not one witness, including himself, not one expert, because the only one they had called in sick, I'm not making this up, during the trial, and then just left it to the 11 other witnesses, including a very compelling, authentic, and truthful E Jean Carroll about what happened to her that fateful day in the department store dressing room. Donald Trump was set up for a loss from the very beginning because he wouldn't take the stand in his own defense. He didn't have an alibi because his alibi was he didn't do it. He didn't know her. It was a hoax. She's crazy. It's made up. And then he would go on to attack her and call it things like, you'd have to believe that I committed hanky-panky, or that I took this woman. He meant in a sexual way, like a conquest in the department store. He himself never used the word rape. So he's now arguing in a motion that he's now filed to try to reduce the jury award from $5 million down to lower than $1 million, and or to ask for a new trial, all within the power of the federal Judge Kaplan, in a motion for what's called remittiture, or new trial. They're asking for both at the same time. They're arguing that the jury had no legal grounds to award as much money as they did for each of these events, the sexual abuse under New York law and the resulting defamation and injury to her, E Jean Carroll's professional reputation, and punitive damages, which, by the way, we thought on the MeidasTouch network and the practicing lawyers in the room, the $280,000 for punitive damages is pretty low, pretty reasonable. Donald Trump shouldn't fight on that. Because it's a very small percentage as a percentage of the overall actual damages that they awarded. But they're fighting that too. And if they do their math, they're telling the judge it's either a new trial judge or it's no more than $1 million. We'll write her a check for $1 million. And they hope, I guess, that the lawyer for E Jean Carroll and E Jean Carroll will say, well, we'll split the difference. The jury's at 5.5 and you're at $1 million. We'll split the difference and take, close to $3 million. Not happening. It's a frivolous motion, yet another one. Second one filed in a week. And it's interesting, there's 2 kind of lawyers that have been representing Donald Trump for all things E Jean Carroll. One, Joe Tacopina, lead trial lawyer. The other one, Alina Habba, who never opened her mouth at all during the trial. And that's not hyperbole. That's not hyperbolic. She didn't say a word. She didn't take a witness. She didn't do the opening statement, the closing argument. She didn't help pick the jury. She just sat there like arm candy at the trial in front of the jury, which I'm sure the jury noticed, including the women on the jury panel, that she wasn't doing anything but sitting there. But she filed a motion earlier in the week that I reported on, another hot take, in which she wants to oppose the attempt by E Jean Carroll to start her new defamation case based on comments that were just made by Donald Trump, calling her, again, a hoaxer. Don't know that woman. It's a shakedown. She's crazy. Didn't happen after the May 9th jury verdict, in which a jury in New York found, as a matter of law, based on the facts, that sexual abuse happened under New York law in that dressing room, and Donald Trump was the sexual abuser, so adjudged, and that she was defamed as a result. And then he defamed her again, and now, rightly so, E Jean Carroll seeking $10 million, including a much larger punitive damage award, to get Donald Trump to stop abusing again and victimizing again the victim in E Jean Carroll, and a judged, proven victim under New York law. And the best that Joe Tacopina, so the motion to try to stop the new case, that got signed by Alina Habba alone, no mention of Joe Tacopina, as if they don't work together. And this motion I'm talking to you about on this hot take, a motion for remittiture to reduce the amount of the jury verdict amount and or award a new trial, was filed just by Joe Tacopina and his law firm and didn't reference Alina Habba at all. Again, really weird. But put that aside for a minute. When you read Joe Tacopina, who was there every day at trial, handled the cross-examination of E Jean Carroll. If anybody knows the transcript better than Joe Tacopina, it would be E Jean Carroll. He said, at best, the jury equated what they heard in the evidence to just, groping, playful groping. He called it groping intimate parts. That's not the evidence that the jury heard. The jury only got hung up on between rape and sexual abuse under New York law, because under the technical definition of rape, it has to be intercourse, penetration, Donald Trump's private part into E Jean Carroll's against her will. That's rape. And because E Jean Carroll had her eyes closed and couldn't tell the difference between whether he was digitally penetrating her with his fingers or with his you-know-what, attention Donald Trump, that's not a good thing for you. But because she couldn't identify it with certainty, the jury checked the box for sexual abuse. We'll put it down for his fingers went inside you against your will. That's sexual abuse. And for Joe Tacopina to cravenly turn that around and call it groping intimate parts and equating it to somebody attacking somebody by touching their breast, which is bad, but not the same bad as what the jury found Donald Trump did in the Bergdorf Goodman dressing room to E Jean Carroll. That was a different and worse bad conduct that got proven by that jury, who was this close to finding it was rape. If only she had opened her eyes and seen exactly what had happened to her, but she's the victim. And she did the best that she could on that stand to testify, as only a victim can. And the jury believed her. And there were no other countervailing witnesses. Donald Trump didn't bring one witness in. All 11 witnesses were on the side of the plaintiffs. So there wasn't even a scale of evidence. All the evidence was in favor of E Jean Carroll. And now Johnny come lately, Joe Tacopina come lately, comes in after his client refused to take the stand, even to put on his ridiculous defense. I didn't meet her. Photo of him meeting her and laughing with her husband, a well-known celebrity newscaster in town at the time, with his then wife, Ivana, right? Where he mistook the photo he mistook E Jean Carroll for his other wife later, Marla Maples. So in Donald Trump's deluded mind that only he operates in, he had two of his wives in the same picture, meeting in a friendly way. That's how demented he is. But I didn't know her. Wrong. Nothing bad happened. 11 witnesses, including ones contemporaneous with what happened at the time, in which E Jean Carroll called friends at the time, just after the event, and reported it, say otherwise. And so does the jury. So here's the prediction. Everybody likes hot takes to hear what's going to happen next, Popok. Here's what's going to happen next. Judge Kaplan is going to deny the motion for remittiture. He is not going to take it out of the jury's hands and reduce the amount after they methodically decided on the counts that they wanted to find and convict, a judge, it wasn't a criminal trial, a judge, Donald Trump, judge him to be, render a judgment against him, a jury verdict against him. And they were very methodical and careful. Sexual abuse, not rape, but defamation. Yes, punitive damages, but not, 7-figure, 8-figure punitive damages, something reasonable. Having taken the time to calculate that over the 3.5 hours that it took them to deliberate, there's no way this judge is going to take that away from them and redo their math and lower it below 5 million or 5.5, and even come close to anything that Joe Tacopina is seeking. and he's not getting a new trial. There was nothing that happened at the trial that shows that the jury didn't do anything other than what they were charged and instructed to do, which was to apply the law of the state of New York to the facts and render their verdict on a special jury verdict form, and then assign dollar amounts once they found for E Jean Carroll. That's all they did. It's what they're supposed to do. And they have an appeal separately. There's an appeal that's, not even quite off the ground yet. We'll have to track over the next year for you. But that at the trial level, motion for remitter will be denied. Motion for new trial will be denied. The motion that was filed earlier in the week by Alina Habba to stop the start of the new case for $10 million for the new defamation will also be denied. And then we'll have to keep an eye on the Department of Justice, which is still sitting on the fence, but now leaning closer to E Jean Carroll about not intervening in the case on behalf of Donald Trump and imposing some sort of immunity on things that he said as president to take him out of the case. Don't think that's going to happen either. Frivolous motion, frivolous motion, frivolous motion after motion. We report him here on the MeidasTouch Network only on hot takes like this. I do about every day. I sit at that intersection of law and politics so you don't have to, and I'll bring it to you, explode the issue, reconstruct it, reconnect it in a way that's logical, so that you have that information in your personal life, in your discussions and debates with friends, family members, and others. And we curate the best of these stories about every week on Wednesdays and Saturdays on a podcast only on the MeidasTouch Network called Legal AF. Wednesdays, Saturdays, you can get it on YouTube, subscribing to the MeidasTouch Network for free, or everywhere you can pull your podcast from, get your podcast from, and all those platforms. If you like what I'm doing, give me a thumbs up. Helps with the algorithms, helps with us continuing to bring this content to you, the quality and quantity of it. And you can follow me, Michael Popok, on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Lock him up. Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.meidastouch.com.